on. So Cartel, Sean Storm, Kyra Jones. I know Andre St. John is still incarcerated because he
No,
is facing
Tahira
another
Jones.
sorry, Kahira Jones, sorry,
Right.
is still incarcerated because he has another charge, right? That he's with which he's dealing. But you're saying that Cartel, Sean Storm, and everybody read through the
Okay.
authorities that you gave them.
They read cases. It's not just
Wow.
persons who you put documents before and they sign. They want to know why is this here. Maybe you can say that. And a lot of what is in their affidavits was what we took from them, and they made
Yes.
sure that, like, listen, this is important to me. I want to make sure that the court knows this. And that was so important. And I think it came over as very impactful in the way that the affidavits
Yes.
were prepared. So it wasn't just, oh, a lawyer sat down at their office and they said, hey, this sound nice and this sound legal. Let me put this here. No, we took instructions
Yes.
from them, and they were very detailed, and they gave us instructions on what it is that they wanted. Listen, they were fighting for their lives. They were fighting for their freedoms. So when people see the
Yes.
judgment go a particular way, it is the hard work, dedication, and faith and trust in God that got us here.
Wow. So they were very integral and very
Very
invested
much
in their
so.
matter. It wasn't a situation like they were hands off and say, yo, I sat her, yo, Mr. Beach, just write anything, yeah, man. Yeah, just come
Nope.
and sign it.
Nope.
They played an integral role in their
Very
matter.
much so. And also
Wow.
their families were as well, because a lot of them had supporting affidavits from their families to bolster what
Yes.
we were saying, because especially in relation to the publicity point, they would be able to speak to it that much because they are in prison. But their families who
Right.
were out and seeing things and hearing things, that kind of information was also before the court, especially
Yes.
as it relates to the publicity issue.
Okay. All right. Very well. So D-Day came and the judges are there. You're in the courthouse now, awaiting the handing down of the judgment. Bring us back to that day. What happened? How were you feeling? And what did the judges say in their handing down? Because I gather that I have perused the document, the judgment, but there were like 12 points that they listed, right,
Right.
as to what they took into consideration to arrive at this verdict, so to speak. But take us to that day in the court. How were you feeling? And what did the judges say?
Well, I won't lie, because we were very anxious, so we just wanted to hear, listen, and I retry them, I did not retry them.
Yeah.
But a lot of prayer went into, especially the day, since the day that we got the date of the judgment, a lot of prayer.
Right.
And listen, I must, I bigger up today on Mr. Campbell's post, but let me just say, big up to Miss Cherry, that is Sean Campbell's mother. Listen, that
Oh,
woman is a praying woman, and when I speak to her on the phone and I hear her bless us and pray for us and cover us and protect us, listen, it is those kind of things that led to this. All the positive energy from the Gaza nation. Everybody was just praying and support. Of course, there's going to be the naysayers and the people who have this and that and a third to say, but we tapped into all of that positive energy and all the persons who
yes.
adopted our mantra of God and time, and we held on to it and we believed in it
Yes.
firmly. This appeal, this part of the appeal, especially, I can tell you, I believed in wholeheartedly that it would never have been in the interest of justice for those men to have been retried. The factors
Right.
just would not have allowed for it. So to hear the Court of Appeal adopt our submissions, and some of them are put into the 12 points that you are that you have highlighted earlier, it was just beautiful to hear
Yes.
and to see that the hard work and the faith that we had in this matter would have turned out so beautifully. I saw a photo that Mr. Palmer posted of himself with his fiance and his daughter, and it was just so beautiful to me, because we know we've spoken to them. We have, I don't know anyone who would have had a better appreciation of what that meant to them except for them themselves. And then I see
Yes.
Mr. Campbell with Miss Cherry playing the piano,
Yes,
and
the
it is
piano.
just
Yes, I saw
another
that today.
beautiful. If you listen to that woman talk about her love for her son, it is something beautiful. And then you just
Unconditional.
trust me, nothing like a mother's love. And then you will
Mm-hmm.
hear Mr. Palmer's children talking about how they've missed their father, how they have
Yes.
suffered because they have not been able to really grow with him. And he was a loving father to them. So persons don't see them as the loving fathers and how Mr.
Mm-hmm.
Campbell would
We
have
see
been
them as the
taking care of his
artists.
needs.
We see them,
Right,
yeah, we see them as the artists, but then they have a family. They have people who love and depend on them and who know a
right.
different side. Yeah.
Right, and
Yeah.
people whose lives were forever changed from the 30th of September for some and into October for others when they were first taken into custody. Remember that from the moment that they came and put cuffs on them, they have not been outside of prison again.
Mm-hmm.
They
Mm-hmm. So
didn't have
tell me now,
the
Mr. Beach.
opportunity to have bail.
Yes, yes. Tell me verbatim now. What did the judge say as she was highlighting? And when did you figure out? Yeah, man. Okay. Yeah, we got it. We got it. What did she say? And what were the points in the judgment that she highlighted?
All right, so of course she would have indicated that based on the allegations, the nature and seriousness of the offense really one that was egregious and that was beyond argument. They had a
Yes.
thing where they were saying what the allegations were. No one can argue with that. They said it rightly in the press summary that it was egregious in nature. Um,
Mm-hmm.
and that that murder is prevalent in our country. So that is
Right.
another factor that would have weighed in favor of them having been retried
Yes.
for that issue to be settled. However, after making that point, she went on to speak about all the other points. What is missing from the press summary, but they did indicate that we must not hold hard and fast to what is in the press summary because there will be a written judgment that will
Right.
speak more in depth and be more authoritative as to what the decision of the court is. The publicity issue did not, in the mind of the court, play as integral a role as we would have hoped in them coming to that decision of the acquittal, what they termed as pre-trial publicity. However, I believe we would have wanted it to be another consideration, not just pre-trial in terms of leading up to the initial trial, but all of it from the initial trial all the way up to if there had been a retrial, which is
Yes.
there's a case called Putman. This is the Putman point that the poison, there was no way
Yes.
of reining that back
Curing
in
that
or
ill.
saving
Yes.
right. So that was
Mm-hmm.
really the publicity issue from our side. We'll see how they treat with that in the written
Yes.
judgment. But the fact is
It's
that
almost
they believe
that case is almost saying that the poison is so inimical to the process. It's like you can't go around it.
right, right. So
Yeah, you
there's
can't go
no
around it.
direction that can be given, nothing that could be used to allow persons to be impartial and unbiased when sitting on
Yeah.
that panel of jury to make the decision. Of course, it
Yes.
is weighed against the point that you always have celebrity persons before the court. That cannot be
Mm-hmm.
something that the court says, oh, because this person is famous, we cannot try him and we cannot find persons who will be able to be unbiased and impartial. But we believe that
Yes.
because of the history of this case and the leaked exhibits, those were the things that would have added to the poison and would have caused them to not be able to be tried by an independent and impartial jury.
Jury. Okay. And then she said the words that you wanted to hear. Which were?
But there were other, of course, it is an acquittal. To God be the glory. God is the
Yes.
greatest. God has shined.
Yes.
But the other point that she raised was the inadequate accounts from the prosecution as to the availability
Mm-hmm.
of witnesses. So they had no affidavit evidence, whereas we tried to make sure that everything we did was backed by evidence. All
Right.
they had was, well, they did have affidavits from other Crown Counsel indicating that these list of persons are available, but not from the witnesses themselves to say, I've been contacted by the prosecution, I am still alive, and I'm willing and able to give
Come
evidence
forward.
again. Right.
Mm-hmm.
So that
Mm.
was absent in this case. Um,
Okay.
as we indicated before, witnesses and trial exhibits were unaccounted for, and persons who would have played a part or who would want to play a part would not be available for a retrial. Of course,
Mm-hmm.
of note is that this is one of the most complex and the longest trials that took place in our jurisdiction. It lasted for 64 days initially,
Right.
and we
Right.
had indicated to the court that if it is that the matter was to go forward to a trial, we would have been objecting to some of the evidence that was used at the initial trial being exhibited
Mm-hmm.
again for the retrial.
Right.
Everyone
Right.
would know by now that there were objections to some of those evidence being tendered at the original trial. We indicate that we would maintain and further object to those things going back again. The cell phone evidence is one. There is technological reports that say that there were issues with the way that the information was collected and even the information itself that was found on the devices. There has been proof now from experts that there was tampering and there were difficulties in how those exhibits were tendered in the first instance. So that would have been a consideration if they were going to have a retrial. You would have to account for the time that it would take to resolve those issues as well.
Yes.
The court spoke to their resources. We know that our courts are strained. There are a lot of matters that
Mm-hmm.
are pending, even without this being a matter for them. So if it is that we were to
Listed,
say,
yes.
okay, let's say a hallmark it for another 64 days, that's at least 3 months of the court resources and time, which means that
Yeah.
persons who are waiting for a trial, they would have to have their
Be
matters
bumped
pushed back,
down. Push
right?
back,
Because
yes. I,
a
and that
retrial
is
would
why
have been
sometimes
given.
and that's why sometimes like say when to sue somebody, you have to think about this thing, because court dates now we're getting like 2025, 2026 dates, you know what I mean,
Right.
because there is so much there are so many matters in the
Mhm.
system. It never makes sense sometimes, really, you understand. That's why some
Mhm.
people even here
Mhm.
on the internet, them chat off them face and them do all kind of thing, but then when you think about it, yes, then you never have no fixed address for me really even find you know have no me care about that. Yeah, it makes absolutely no sense, you know what I mean.
Mhm.
Yeah, yeah,
Mhm. It takes
at this
time, and
point, yeah,
it
yeah,
takes time. Our system is already severely strained. I think that our Chief Justice is doing a wonderful job in terms of
yes,
how the court administration has been dealing with matters, but there's just so much that can be done and no more with the matters that already exist. And despite their earnest efforts to try to get them out of the system and disposed of. So that is
yes,
definitely a consideration. It would be at a great expense to the court. Everyone would have seen how they had to be cordoning off the area in relation to the appeal matter, the retrial issue. So imagine if it is that this matter would have gone to court and they would have had to be maintaining those kind of security presence and so on for 3 months. Think back to how the
yes,
expense of the Klansman gang trial and how much
yes,
of the state resources were spent. Listen, we just came out of a hurricane that we're still trying to um,
mm-hmm,
recover from.
mm-hmm,
There's a lot going on in Jamaica, and so those are things that definitely have to be considered and were considered in relation as to whether or not there was going to be a retrial. Um, they talked
so let
about
me let
the
me yeah, they spoke about, so go ahead. Mm-hmm.
I was going to say they talked about the psychological, financial, and medical effects of a new trial. As I
Yes,
said, we had the report from the psychologists and the medical doctors to speak to those things along with the affidavits of the men. They spoke about the issue of delay, the period of time between the commission of the alleged offense and the possible time that it would take to get the matter to a retrial, even if it was given the special retrial considerations, because those matters are given preference because they would have been going on for a longer time, and so they would
yes,
have wanted to have them disposed of, because especially for some of these cases the persons might have been in custody for long periods of time. The other factor
yes,
they considered was the unjustifiable. interference with the appellant's constitutional rights. Now, the prosecutors did say in court, they admitted that they had breached the men's constitutional rights,
Oh,
and
they did.
they did. So that is undisputed, and they did not go on to apply the Oaks test to say that it was demonstrably justified in a free and
Justifiable in a
democratic society,
free and democratic
right?
society.
They didn't
Yes.
speak about any least respective measures. They didn't do any of that kind of justification. So, on their own admission, and as the court has indicated, it is the unjustifiable interference with the appellant's constitutional rights to a fair hearing. The other issue was the potential prejudice that at least two of the appellants would have faced. That would have been Mr. Jones and Mr. St. John, I believe, in relation to the period in which they would have been able to be eligible for parole.
Right.
What the court indicated is that if they were convicted after a new trial, they would be required to serve a longer term of imprisonment before they
Right.
would have been eligible for parole. Some of them would have actually served their parole time if it went to a retrial. By the time it was retrial, they would have served the entire
Yes.
parole time
So they would have to start
before.
over, which is
Right,
inhumane and unjustifiable.
right.
Yes.
Right. So those things are given consideration. We're given
Okay.
consideration. And what the court at the end said that having weighed all the relevant considerations in the balance, because it is a balancing exercise,
Right.
once it is that you're going to have a retrial, there are a lot of factors. And it is the weighing of those factors that will determine whether or not there's going to be a retrial. And they said
Okay.
that the court concludes the interests of justice do not require that a new trial be
Yes.
ordered for the appellant, and the court therefore orders that judgments and verdicts of acquittal are entered in relation to the appellants, and there began the joy unspeakable.
Wow, 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 wow. I guess they heard wherever they, were in their cells, what the verdict was and what the outcome
Right,
was. I can
right.
only imagine the jubilation that they
Mm-hmm.
must have felt. But one of the questions, so they're out, everybody saw it all unfold on
Mm-hmm.
TikTok, on, social
Mm-hmm.
media and in traditional media as well. And, of course, the fans, family members were quite jubilant about what would have transpired. But
Right.
at this juncture, persons are asking whether he is going to sue or the gentlemen are going to sue for my brain, yeah, for malicious prosecution and or false imprisonment. And so I wanted to, we are creatures of instructions as attorneys, so it
Right.
depends on what the clients want to do, and it depends on what the client instructs us to do. But from
Right.
where you sit, would that be plausible? Would that make sense to sue for malicious prosecution and false imprisonment?
Well, as it relates to malicious prosecution, what they would have had to satisfy was that there was a criminal offense, they would
Mm-hmm.
have been acquitted of the charge, or it was determined in their favor, and that the prosecution set the law in motion without reasonable and probable cause.
Mm-hmm.
I believe, and the last thing is that in so setting the law in motion, the prosecutor was activated by malice.
My malice,
Um,
yes.
right. So the hardest part, I believe, of this would have been that the prosecution was set in motion without reasonable and probable cause.
Exactly,
No,
because with
there's
all
a
the
lot.
evidence, with all the
Right,
forensic evidence, with all the witnesses, it's going to be a very
right.
difficult task.
Hurdle, right.
Hurdle to
So
prove
I'm not
malice, yeah.
giving any pronouncement on it. Internet, do not come for me. Like on the come for me before, please. Please, I am begging. I wave the right flag. Um, I'm not making any pronouncement, but that would have been the greatest hurdle if it is that they were doing that. And I can tell you right now, they're more concerned with reintegrating into society and spending time with the people who they love, who they've not gotten a chance to see in 13 years. They would have
Yes.
seen us. The Messiah was tired of doing overcome no and collect instructions and do affidavits. But they are now with the people who they love, who miss them the most and who
Hmm.
most suffered from their absence. um, from being able to see them, touch them, and hold them. And that's why I tell you, those moments that are captured now, they are so beautiful to
Priceless.
see. Trust me.
Yes.
Even now, it's
Yes.
like, we really did it. They're really free.
Yes.
So I can just imagine. Because first of all, I know they, they're just now going to know what it's like to skate on the toll. There was no
Yeah.
toll like that when they
Yes.
went into prison. Come on now.
Yes.
Even just the
Yes.
journey, I can imagine, from the prison to their homes must have been like,
Yes.
listen, the place was
Wow. All of
different.
this happened
Even
while
the
we were away.
waterfront,
Yeah.
right? Even the waterfront is
Yeah.
developed. Like, I remember the first time I saw it, and I'm out here, in these streets. The
Yes.
first time I saw it, I was like, okay, this just look different. It's like I was driving a different place, just a little painting and like
Yes.
a project that we did done by the waterfront. You can just imagine them now leaving prison
Yes.
and
Taking it
making that
all
journey
in.
home. Listen, I
Yes.
was joking the
Yeah.
other day with Mr. Buchanan. I'm like, listen, you see them supposed to go Ocean now, you go this, them go Flatbridge and go around
Yes.
Morgantown. They don't know that it's a
Yes.
toll. And that's just
So
the
yes.
reality of persons being away from society for so long. It's going to take an
Yes.
adjustment. I
Yes.
go visit my mom, and there are persons who have put up houses and so on in the little time. Like, probably I take like 2 to 3 weeks between visiting my mom. And every time
Yes.
I go there, there's a new thing directed, and it just changes the whole area and ambience of making that journey. So I can just imagine what 13 years has done for these men.
Yeah.
So I'm just happy that they're
Wow.
taking the time to kind of soak it in and really spend time with the people that they love. Nothing, I think, can beat that for them,
Yes, and
because
I
you
think
hear them
especially
talk
for
about
Mr.
their
Palmer as
love.
well. For Mr. Palmer as well, obviously his health situation needs urgent
Exactly.
attention, right? And before,
Mm-hmm.
I know a lot of persons are very excited and waiting with bated breath for the announcement of when the party gonna keep and the concert are gonna keep. But I think
Mm-hmm.
what is the matter at hand that is most important is his health,
Is it
because if
health?
he's not
Right.
healthy and strong, then he can't perform if that is what he so chooses
Right.
to do. So
And I
that
want people
is.
to understand, it is no joke thing. He really, really and truly is very, very ill. And he is, as far as I'm aware, making every effort to ensure that he's in the best of health, given that he's had the opportunity of his freedom. We made sure that we did what we needed to do to ensure that he was taken care of when he was in there. But I'm happy, elated that he is now able to go and get the help that he needs to fully and better recover. Trust me, that is phenomenal. And I'm grateful that the Privy Council was able to take it as a serious matter, which would have expedited the hearing date for the Privy Council leg of it. We did an application for that to be facilitated, and they were mindful of that when in the way that they were able to facilitate the hearing and the delivery of the
Yes.
judgment. So I'm grateful for that, and I'm happy that our Court of Appeal as well took steps to ensure that they did not languish with the matter, and that we got a judgment in record time. So I'm really, 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 really happy. So I hope that people don't think it is a stunt. It was not a stunt. It is not a ploy. It is not a phantom thing. It is very real that he is ill, and he's trying to ensure that he gets the care and attention he needs. Of course, when the time comes, he will speak for himself and say what is going on. But I think it is important, because I've seen it out there. People are saying, "Oh, probably we just did it to get the judgment in his favor." And people say all kind of things, but don't joke about people's health and their
Health.
safety.
Yeah.
They did the same
Yeah.
thing for the gentleman who played the Black Panther until they found out that he had cancer. Don't
Yes.
joke
Yes.
about
Chadwick
people's
Boseman.
health. And remember,
Yes.
the same knife will stick sheep, will stick goats. So don't end up in a position where you're making fun of someone and their sickness and their state, and then you see the